argument goes that the court failed to make a proper investigation into the correctness of Israel's position. Now, I'll give you three reasons why I think this criticism is invalid. First of all, the onus was on Israel to prove that this was the purpose of the construction. But Israel chose not to appear before the International Court and to make submissions on the reasons for the construction of the wall. In this case, Israel failed to behave as South Africa did in 1971 when the court gave an advisory opinion on Namibia. South Africa appeared before the court and presented legal arguments, which were not accepted, but South Africa did the decent thing and appeared before the court. But Israel simply refused to appear before the court. It was in law entitled to do so, but it's very difficult for Israel to come along later and say, well, you didn't consider our arguments, but Israel never raised these arguments before the court. Secondly, I think it's very difficult to argue that one may construct a wall in foreign territory for the purposes of security. Imagine if Canada decided that it wished to build a security wall to protect it against the United States. And instead of building it along the Canadian border, it built it within the territory of the United States. It's very difficult to justify the construction of the wall within Palestinian territory as a security measure. But the main reason why I say that the Israeli argument is invalid is that at the time the case was argued, it was shown that the purpose of the wall was to incorporate Israeli settlements in the West Bank, that is, into Israeli territory. It was pointed out that the wall was constructed in such a way that it enclosed 83% of Israel's settlers in the West Bank, some 69 settlements. So, on the face of it, it seemed that the purpose of the wall was not to provide security to Israel, but rather to seize land for Israel by incorporating settlements into Israel. In 2004, Israel denied this vehemently, and Israel kept up this pretense for several years. But in more recent times, Israeli politicians have been much more honest about it, and they said quite openly that the purpose of the war is largely political. It's not built in Palestinian territory for security reasons, but to enclose or to incorporate Israeli settlements into Israel's territory. So today that argument that was raised against the court has simply disappeared, because it is acknowledged by Israel itself that the purpose of the war is both to provide security, and you can acknowledge that that could have been done by building it along the Green Line, the boundary between Israel and Palestine. So the main purpose, it seems, was largely to seize land for Israel by transferring the settlements into Israeli territory. Well, so much for the opinion. What about the authority of the opinion? As I said, it was adopted by 14 to 1. The sole dissentient was the American Judge Bergenthal, but I think it's important to stress that Judge Bergenthal agreed with many of the findings of the majority. He agreed that Palestinians have a right to self-determination. He agreed that the human rights covenants are binding on Israel and the territory. He agreed that the Fourth Geneva Convention is binding upon Israel. He agreed that settlements are unlawful. So one can really say that 14 and a half of the judges of the International Court agreed with the finding of the court. Of course, it is an advisory opinion, and as the word suggests, it's not binding upon member states as such. As the opinion declares the law, Israel is obliged to comply with the law. It's obliged to acknowledge that the human rights covenants are binding upon it, and the Fourth Geneva Convention is binding upon it. But as an advisory opinion, it's not binding upon Israel, it's not binding upon the United States. But it is binding upon the United Nations, because it is the law of the United Nations. It's the law as declared by the judicial arm of the United Nations, and so it is the law of the United Nations, which means that the United Nations, and particularly the Secretary General, is obliged to comply with it. Now, what has happened to this advisory opinion? How has it been treated? Well, first of all, it's been completely ignored by Israel. Israel has proceeded with the construction of the wall. Some 200 kilometers have been added to the wall since 2004. Settlements have increased. Checkpoints, roadblocks, another issue that troubled the court, have also increased. We now have over 600 roadblocks and checkpoints which obstruct Palestinian freedom of movement. Quite clear that Palestinian self-determination has suffered, not only as a result of the construction of the wall, but also as a result of the separation of Gaza and the West Bank. And of course the humanitarian crisis has also worsened in the West Bank and in Gaza. So it's, I think, very fair to say that Israel has not only ignored the opinion, but that the situation has deteriorated substantially since 2004. Has the international community done anything about it? Well, in 2004, the General Assembly did approve the adoption, or adopted a resolution approving the advisory opinion. That resolution was adopted by 150 votes to 6. That 150 included all members of the European Union and the Russian Federation. The 6 included Israel, the United States, Australia, that wouldn't happen today, I hope, and of course the 3 major powers in the South Pacific, Micronesia, Marshall Islands, and Iran. But what about the Security Council, the most important organ of the United Nations? It has done nothing. It has not adopted any resolution, giving any acknowledgement, let alone approval, to the advisory opinion. That's because of the US veto. Then we have the strange body called the Quartet, comprising the United Nations, the Russian Federation, the United States, and the European Union, which is supposed to be responsible for furthering the peace process in the region. This body meets every 3 months and adopts high-sounding statements and does little else. But the interesting thing is that these statements never even mention the advisory opinion, despite the fact that it is, after all, the law of the United Nations. And I think that what is very unacceptable is that the Secretary General of the United Nations, Mr. Ban Ki-moon, never even mentions the advisory opinion himself. He's made many statements on the subject. He always refers to this so-called roadmap. He studiously avoids any mention of the advisory opinion. Now, I think in order to understand the position of Ban Ki-moon, one should compare him with the President of the United States at the time of Brown versus the Board of Education. You will recall that President Eisenhower was then President of the United States. He didn't like the opinion, the judgment of the court. He didn't like the Chief Justice who he had appointed by mistake, he said. But President Eisenhower did accept the judgment of the Supreme Court in Brown versus the Board of Education. He said that it was his responsibility and duty as President to observe and to implement the judgment of the court. You will recall that he even